afternoon, everyone, and thank you so much for joining us. We're just giving it another minute or so while some more people are joining, and then we will officially begin. Yeah, I think that's most of the attendees we've been expecting, so we will crack on. Good afternoon, everyone, and thank you so much for joining us in what we hope to be a series of informative business immigration webinars in the future. Before I introduce our speaker today, some housekeeping. Everybody is muted by default and your cameras will automatically be off, so you do not need to click anything. You'll be able to see the presenter speaking as opposed to other attendees. At the top of your screen next to the settings bar, you should see two arrows. If you click on that, it will let you maximize your screen should you wish to see us even bigger than we are now. There's also a chat function at the bottom right. We have ensured that the chat is public in case there's any duplicated questions, and we do have an expert on the call who will be answering questions as Darren is speaking. So please feel free to post any questions you may have in the chat as we go. If you have questions that are direct, specific, or sensitive, you're welcome to reach out to us directly. Our contact details have been shared and will be shared after the webinar, and you're welcome to reach out for a free, no obligation conversation. Just to give you a quick overview of what Sable International does, we're specialists in immigration and international financial services and have been providing a boutique range of services for over 30 years. We have offices around the world and are generally able to provide a bespoke, customer-centric service suited specific to our clients' needs. To introduce today's esteemed speaker, we've got Darren Faife. Darren has over 25 years experience heading award-winning organizations and providing immigration and compliance services to large-scale multinational businesses. Having run his own successful immigration practice for over 20 years, Darren possesses a strong commercial mindset and provides an effective delivery of strategic solutions. Darren more recently has joined the Sable International team with his wealth of knowledge and experience, and I have no doubt he'll be able to provide us all with some great insight into the post-Brexit business immigration regime. So Darren, without further ado, over to you.
Thanks, Saskia. Hi, everyone. Today, we've got quite a bit of information to kind of run through, so it will be quite detailed, but I'll try and race through it as much as I can. We will be sharing the presentation with all attendees afterwards, and you'll be able to rewatch this as it's being recorded. Today, we are going to cover a number of topics. I'll initially take us through a bit of background information to explain how we are where we are. I will touch upon sponsor licenses for those of you who aren't familiar with being a UK registered sponsor. And then we'll talk about the new skilled worker scheme, which replaces the Tier 2 scheme. A couple of case studies just to put it into context. And we'll also talk about intercompany transfers, home office costs, process, timescales, a couple of different immigration routes that are coming through as well later this year, which may be of interest. And we also need to talk about EU workers that you may already have in your businesses, because of course it's been the withdrawal from the EU that's really spurred all of this stuff on. So we'll talk a bit about that, and right to work checks, and obviously that's going to be changing too, as we have more nationalities now requiring immigration clearance. It will impact the systems and processes we have in our businesses when we're onboarding new staff members. So we will dive into a bit of background. Now, essentially, this is, as I said, it's being driven by Brexit. As we all know, the UK left the EU at the end of last year. And for those individuals that were already in the UK, so those EU nationals in the UK by the 31st of December, they are able to preserve and protect their rights to live, work and study in the UK. In order to do that, they must make an application under the EU settlement scheme. and there is a transition period between the Brexit date, which was 11 p.m. on the 31st of December, and the end of June this year. So we have a 6-month window to sort out that population, and they must in order to preserve their rights, they have to make an application under this new scheme. For anybody outside of that, anybody entering the UK after the 1st of January, they will require work permission if they're going to be working. They can still come to the UK as a visitor. Similarly, we can still go to Europe as visitors without requiring a visa. But if we want to do any kind of work, then we must have prior permission. EU nationals will need to present valid passports moving forward. Traditionally, they've been able to travel just by waving their national ID card. That's all going to be changing from the 1st of October, where they will now need to present a passport with at least 6 months validity. So it's all changed really for our relationship with the EU. It is a massive shift. So the big takeaway really is anybody from the EU is now treated like any other foreign national when entering the UK for employment. Okay, i.e. they will require permission to take employment under this new points-based scheme. Now, before anybody can obtain a work visa, they're called certificates of sponsorship, the employer must first have a sponsor license. Now, I suspect many of you on this webinar today already have one, but for those who aren't familiar, let's put this in perspective. What we have is a lot of employers haven't needed a sponsor license previously because they've been able to recruit from within the existing resident pool of labour, and that's included the 27 EU countries. Now we have a situation where those 27 countries are no longer visa free. So we're going to find ourselves with employers requiring a sponsor license where previously they had no reason to do so. And so we'll go into that a little bit. Now, it's pretty straightforward. We make an application to UK Visas and Immigration, which is part of the Home Office, and they can issue you with a license, which will be valid for 4 years. Any UK employer that wishes to employ a non-resident, non-British individual must have this sponsor license in place before they can even think about having that person work for them. The Home Office essentially will give you permission to issue your own certificates of sponsorship, i.e. your own approval letters for the person to then go get their visa and travel into the UK. But along with that responsibility comes some obligations. And the obligations to the Home Office is that you have very robust systems and processes in place for preventing illegal working, i.e. you must have a documented system around how you onboard and check right to work for employees. You must have very robust record keeping. You must maintain their contact details, not just their current ones, but historic ones as well. Should the person go to ground, for example, and the Home Office want to try and track them down, they would put that responsibility on the employer to maintain that information. You must know where the migrant is at any given time. So if they're not in today because they're working from home, there must be a system in place for recording that. And there are also other more general duties, such as if the role changes, if their location changes, there are reporting responsibilities that the employer must fulfill for the Home Office. So that's the sponsor license in a nutshell. It is a subject all on its own. So if you do have any questions around that, it would be something that we could certainly assist with. Now, the skilled worker category replaces the Tier 2. And the Tier 2 was the Emperor's new clothes of the original work permit. So essentially we're dealing with the same thing, work permit, Tier 2, skilled worker, all effectively the same thing, but with different names and different systems in place. So the skilled worker category runs on really 3 main principles. The individual must have a job offer from a Home Office approved sponsor. So as I said earlier, you've got to have that sponsor license. The skill level of the role must be of a sufficient level. Now, they've recently reduced it to RQF level 3, which is A-level standard. Under the Tier 2 scheme, which was in place up until the end of last year, that was RQF level 6, which was degree level. So what that's meant is that many more occupations now fall within the scope of the scheme. So many roles that weren't considered sufficiently skilled now fall into it. So what we're seeing are a greater number of jobs that fall into it, but two employers who can now benefit from the skilled worker category. The third principle is salary. And again, salary and skill level kind of go hand in hand. It's an indicator of how important an individual is to you. So if you've got a role that's paying, 14k a year, then the Home Office would say, well, it's unlikely that role is going to be of a sufficient skill level to meet our requirements. So they use salary and skill level together to establish whether or not a role is sufficiently high level. We also have an English language requirement on the skilled worker category and a criminality threshold. Those are unchanged from the original Tier 2 scheme. What is new is that they have removed the cap on the amount of people that can have a Tier 2 or a skilled worker visa now. Previously, there was a cap, and there is no longer a resident labour market test. So, in other words, in simple terms, that means advertising. Under Tier 2, we had to advertise for at least 28 days before we could even make a request to the Home Office for the certificate of sponsorship. That's no longer the case. Expanded skills threshold, as I just mentioned, and tradable points, which we'll come on to. So there are certain points that are core and certain that can be traded. And a big change is the ability to switch. So you can switch from one category into the skilled worker category, even if you're already in the UK. Okay, there are exceptions to that, such as visitors, but in many cases, what was previously prohibited from switching, is now allowed. So that's a real bonus for employers. So coming on to the core points, we have a total of 70 points that we must achieve in order for somebody to qualify for the certificate of sponsorship, 50 of which must come from this core area. Okay, so these are non-negotiable. And first of all is the job offer must be from an approved sponsor. Pretty straightforward. The skill level must be at least IQF level 3, as I mentioned, and they must have sufficient knowledge of English language. Okay, so those three are the non-tradable, non-negotiable points. The additional 20 points can be made up around salary. Now, if somebody, what you have is when you issue a certificate of sponsorship, the job the person is coming to do has a very specific occupation code. And in that occupation code, the Home Office will tell you this is the minimum salary level for that role. If you fall below that, you can potentially score points if you have a PhD or you're in a shortage occupation role. And by shortage occupation, it must be on the official list of shortage occupations. Certain engineering and medical roles are on there. Or if you are a recent graduate or under 26. So in most cases, people will fulfill the salary at 100%. Okay, they'll be earning the right amount of money for that role, and they'll get their additional 20 points there. For those that are a little bit less than that, and we can see at the bottom here, it says applicants must earn more than a lower limit of 20,480. That's 80% of the actual bottom limit, which is 25,600. So 25,600 is the new minimum threshold. And if you're earning 80% or more than that, 80% of that or more, then you can look at trading points. But it will only impact you if you're in a shortage occupation role or it's PhD or one of these other categories as mentioned there. Another big change for skilled worker is there is no cooling off period. Under Tier 2, an individual that spent time in the UK on a Tier 2 visa, if that lapsed or if they left the UK and it expired, they would need to leave the UK for at least 12 months before they could return on another Tier 2 visa. Under the skilled worker category, there is no cooling off period. So somebody could be in the UK in a Tier 2, leave the UK for 3 months and return to the UK again on another skilled worker visa. There would be no cooling off period. Additionally, the Tier 2 visa had a restriction on how long a person could continually extend their visa without applying for indefinite leave to remain. Now, ordinarily, a person will qualify for indefinite leave to remain after 5 years of being on the previous Tier 2 visa. And if they hadn't obtained that within 6 years, they'd need to leave the UK, complete a cooling off period for 12 months before they could then return to the UK. The Home Office have said, now there's no cooling off period, we can also remove the limit on the amount of years a person can be on the skilled worker visa. So they can continually extend, although they could potentially qualify for permanent residency, indefinite leave to remain, after a period of 5 years. As I mentioned earlier, the cap is no longer in place. It is suspended. So the Home Office are reserving the right to reintroduce that. I think we're going to see a huge surge in numbers. I think that's undoubted. And the Home Office need the ability to put a lid on it if it gets out of control. Okay, so that's, for now, it's suspended. We don't need to worry about it. And we also don't need to worry about the resident labour market test. That's not suspended, that's been removed. So we have, it's quite an interesting situation where a lot of people thought Brexit would bring back this massive amount of control around immigration, when effectively what's happened is, yes, that's happened, but then now they've introduced a scheme that's lowered the skills level, removed the cap on it, removed the requirement to even advertise a role, and really opened it up to even more individuals than before. So equally, they've reduced the skill level, they've reduced the salary entry requirement, which was 30k, now 25.6. They've introduced the ability to trade points. If you can't quite make the 25.6, maybe you can qualify somewhere else because you're in a shortage role. So they've been very, very flexible. And they've also reduced the entry requirements for indefinite leave to remain to coincide with the new minimum salary requirements under the main scheme. So big changes. The other thing to note here is that the salaries quoted here are based on a 39-hour week. So you can prorate that depending on how many hours the individual's actually working. To put this into some kind of perspective, I've got a couple of case studies here. Case study one, we've got Tom, a planning assistant, who is looking to fulfill a role of 26.3. He meets all the mandatory criteria. He has a job offer from an approved sponsor. He's at the right skill level and he's got English language. So he gets his 50 points there. And because the minimum threshold for planning assistants is 22.4, he's above that at 26.3 and he gets the 20 points under salary. So straight away he gets in 70 points, no problem at all, very straightforward approval. Case study two, slightly different, where we have an individual who again scores the main 50 points under the mandatory section, but she's an aerospace engineer and the minimum entry requirement for aerospace engineers is 33k. Her salary will only be 29, so she's 4k short. However, because 29k is above 80% of 33k, she can then look to see whether or not she qualifies elsewhere with her tradable points. Aerospace engineers are on the official shortage occupation list, and therefore she scores 20 points for being on that list. So because she's in the shortage occupation, she can trade points and achieve the 70 points. Some things to be aware of is that the skilled worker route should allow for shorter lead times. Not only do we not have to advertise the role for 28 days, there is no longer going to be this monthly cycle. So under the Tier 2 scheme, you had to make an application, you had to apply to the Home Office after your advert had ran for 28 days. But the Home Office would only consider cases once a month. So I think you submit your application on the 11th and they'll give you a decision by the 18th. So should your advertisement not be 28 days old by the 11th, you would then have to wait until the following month. So for example, if your ad was 28 days old on the 12th, you were too late for that month. You have to wait another whole month before they'd even look at your application. So all that's been removed. So we can absolutely kind of save at least a month, if not two, at the front end of an application. On the other side, we are likely to see high volumes because, well, one, we have more roles that fall into the scheme, more people that qualify, but two, we've also got more applicants because we've got these 27 more countries that now need approval. And let's not forget that EU workers form about 7% of the entire UK workforce. So it's quite a large uplift in individuals that will require approval who previously didn't require anything at all. The immigration skills charge and the immigration health charge will continue to apply, including all EU hires, and I'll go on to fees in just a moment. But the certificate of sponsorship fee of 199, which, to be fair, is the smallest portion of any immigration fee, is being waived for most of the EU member states, apart from those 6 listed there: Bulgaria, Estonia, Lithuania, Romania, Slovenia, and Switzerland. For those companies that already have a license, we do need to think about the systems and processes and make sure everything's up to scratch. We're now going to be managing a much larger sponsored worker population that will come under the scheme. We'll need to be looking at how many certificates of sponsorship you may need in any given year, and then add in any of your EU hires. And another thing that a lot of companies haven't thought about is adding overseas EU branches to your license. Traditionally, companies have only had to add their overseas branches from the countries which they are bringing their intercompany transferees. And they've often left out the EU because, well, anybody travelling between those locations hasn't required any approval, so there was no need to add it to the license. But looking forward, we will need to now be doing that. So it's just something to think about. Speaking of intercompany transfers, the scheme with intercompany transfers has not been updated as much as the skilled worker category. And this creates an interesting situation where intercompany transfers are becoming much less attractive to employers. And you can see here that in normal circumstances, in order to bring somebody, transfer them across from one branch into the UK, they must have been working for the company for at least 12 months, unless they're considered to be a high earner or a grad trainee. But as you can see here, the role is left at the original RQF level 6. So where you had RQF level 3, A level, for a new worker, if you were transferring somebody in, they had to be operating at a much higher level, i.e. degree level, RQF level 6. In addition, the minimum salary threshold, instead of being 25.6, is now 41.5. So the entry requirement is much more difficult for intercompany transferees than it is for skilled workers. The intercompany transfer migrants haven't traditionally been allowed to switch once they're in the UK. So if a company brought somebody in on an ICT visa, intercompany transfer, that person was really tied to the employer. They couldn't change employer. They couldn't apply for a tier 2 visa because ICT didn't allow that. And if they went back home, they'd have to spend 12 months out before they could come back again to work for another employer. The new scheme allows those people on ICTs already to switch into skilled worker. So now ICT holders have kind of been released from their shackles, and anybody in the UK on an ICT is now free to work for another employer, or indeed switch to the skilled worker category. Again, the skilled worker category leads to settlement. It leads to indefinite leave to remain after 5 years. The ICT visa doesn't. So again, a lot of individuals that are here on intercompany transfer visas, even if they're not planning to join another company, they would probably in all likelihood, are going to want to switch onto the skilled worker because it gives them more options down the line. It gives them the ability to get indefinite stay and ultimately get a British passport if that's something that they desire. So some big changes on the tier 2 skilled worker side, not so much on the intercompany transfer side. To illustrate the changes and the differences, we've put this table together. And you can see that the intercompany transfer on the right-hand side was designed for temporary employment. It was just to bring somebody in for a short period and then they would return overseas. And because of that, they haven't got the ability to obtain indefinite leave after 5 years. Where our skilled worker, it's a permanent local hire. So there is an expectation that individual is going to settle in the UK, and therefore the skilled worker, you can get indefinite stay after 5 years. But just looking across that table, we can see that the skilled worker category is much easier. There's no previous experience required, the skill level's lower, the minimum salary's lower, and it leads to settlement where the intercompany transfer doesn't. So much more attractive. The downside is that the skilled worker category has an English language requirement where the intercompany transfer doesn't. And the reason for that is that a lot of Japanese manufacturing companies made representations to the Home Office when this was first introduced. And they said, look, our guys are coming to the UK for 3 to 6 months, working on Japanese machines that are, all the instructions are in Japanese, the manuals are in Japanese. They are living, with Japanese. There's no need for them to have an English language requirement to do the job we need them to do. So the Home Office said, okay, fine. So there is that concession for intercompany transfers. There's no English language requirement, but it's the only advantage. Everything else is much more simple on the skilled worker route. So that would be our advice. It will be interesting to see how long the intercompany transfer category remains. So I don't think many employers are going to be using it. From a cost perspective, immigration is an expensive business. We have initially the sponsor license, which isn't actually too bad considering that will give you the ability to sponsor however many migrants you can justify for a period of 4 years. So if you broke that down across the amount of people that you may employ, it's a very small sum. A certificate of sponsorship is £199, and that's the fee that's waived for EU nationals. But then we have the immigration and skills charge, and you see there's 2 fees here, and it depends on whether or not you're what they consider to be a small user or a large user. And on the right-hand side there's an explanation of what dictates that. But the immigration skills charge was designed to create a fund to upskill resident workers, i.e. our British nationals, to be upskilled so employers wouldn't be so dependent upon bringing in foreign labour. Okay, I don't think I've ever seen any evidence or explanation as to where that money goes, but that's the idea of it. And the immigration health surcharge is to fund any NHS requirements. The difference with the skills charge and the health surcharge is that the skills charge only applies to the main applicant. So if any trading dependents are accompanying them to the UK, there is no skills charge. It's just for the main person that you're sponsoring. The health surcharge, however, applies to each individual, and these are per year sums. So it's £624 per year per person, and similarly, the immigration skills charge is either £364 or £1,000 per year per main applicant. Okay, and as we can see, we look at the bottom, your costs are around about the same. We've got out of country and we've got in country, quite similar fees, but you're looking at around the £1,200 to £1,800 per year of cost for a single sponsored migrant. So it's not an insubstantial amount of money, particularly for smaller employers, and of course it now impacts many more nationalities. So that's the cost. Well, I'll talk you through quickly the process and timescales. For those of you who have not already got a sponsor license, it's a relatively straightforward process, but it does take a couple of months, and there's every chance that you will be visited by the Home Office to ensure that you've got the systems and processes in place to fulfill your obligations. As I mentioned earlier, around right to work, record keeping, reporting changes, maintaining contact details, all that kind of stuff. So they're going to be interested to know, what have you actually got in place? How does it work? How do you do it? If someone doesn't turn up for work, how do we know we're going to find out about it? What does that process look like? So to start with, it's an online application where you should submit your supporting documents, such as your accounts, details of your premises, your insurances, pretty general company info. And they will conduct a risk assessment based upon any number of factors. Could be the size of the company, could be the sector that you're in. If they feel that your sector is a high risk, high fraud sector, then there's every chance the next thing you hear will be arranging an appointment to come and visit you. And I want to check out that you are a bona fide organisation. Once they're happy with the whole thing, they will then issue your sponsor license, and then you're free to start issuing certificates of sponsorship. So your sponsor license is likely to take up to a couple of months, assuming there are no delays with organising appointments. Obviously, we have COVID, so physical compliance visits are quite challenging. So there's it's 4 to 8 weeks is a pretty standard kind of time. And again, similarly, it's 4 to 8 weeks from issuing your certificate of sponsorship to the candidate being able to get their visa and enter the UK. The process again is online. So your request for a defined certificate of sponsorship is conducted via the sponsor management system, which you'll have access to once you have your license. The Home Office will issue an approval, normally within a week. And then once you have the approval, it's an online document. So you will generate your certificate of sponsorship unique reference number using the sponsor management system, and you will communicate that to the individual, and they will then use that PDF document and reference number to make their visa application overseas. And they'll attend biometrics and all the rest of it, just like they would for any other visa application. So to wrap up on skilled workers, we need to remember that EU nationals are now treated exactly the same as any other foreign national. Okay, so we need to look at the French national wanting employment just the same as we would an American national coming to the business and saying, can you give me a job? It's exactly the same. So there needs to be a bit of a mind shift there. We can't have a situation where individuals arrive in the UK and think we can make the application after we've arrived. Okay, this is something that must be done pre-entry to the UK. So they do require entry clearance before they can board a plane, arrive in the UK and start work. So it's not something we can do after they've arrived. We've got these two main routes. We've got the skilled worker and the intercompany transfer, both of differing entry requirements. Very little point in the intercompany transfer unless English language is likely to be a problem, or if it's very short term and all the other criteria is met, that's not a problem. And we need to just be mindful that the sponsor license now will support a much larger population. So you'll need to look at your existing workforce, look at your trends regarding onboarding recruitment, and kind of extrapolate that out as to how many certificates of sponsorship you're going to need moving forward in the new world. We also have a couple more immigration routes coming on stream, and these will be in addition to the skilled worker and intercompany transfer categories. We have the highly skilled worker category, which is currently under review and consultation with the Migration Advisory Committee. This will be a sponsor-free process, so an individual will be able to make an application on their own merits because they are either highly educated, qualified, and can essentially self-sponsor into the UK. So these guys will be limited. I imagine there'll be very few people that will qualify for it, knowing from previous schemes in the past. But it is something that they're talking about introducing this year. I think of more interest is the graduate scheme, also known as the post-study work. The Home Office had pretty much the same scheme in place, which previously they abolished it in 2012, reintroducing in 2021, and it allows recent graduates in the UK to apply for an extension, and they can do whatever they want. They can work at any skill level. There's no English language requirement. Normally they've been educated in English anyway, so it's never a problem. And the beauty of it is they can use this visa for a couple of years. So your graduates get a 2-year visa and your PhD students get a 3-year visa. And within that period of time, they can find themselves permanent employment and switch into the skilled worker category later on. The advantage to employers is that this is a pool of resource who do not require any work on your part. You can just employ them. We're waiting for an update on when this is likely to be introduced. We have been told it will be in time for the graduate intake for this year. So we'd expect more news around summer. So I think we want to just quickly touch upon what kind of kicked all of this off, and that's our EU workers. EU workers are, as I said earlier, they form 7% of the total UK workforce. So it's quite a number. And a lot of employers have approached us saying, well, what do we do about everybody who's already here? And how do we kind of manage the population? So as I said earlier, those that were in the UK before the end of last year are protected by the withdrawal agreement. But they're only protected if they can make this application by the end of June. So there's this transition between us leaving the EU and by the time those individuals that are already in the UK need to have their status sorted out. So this 6 months is quite important, and we need to ensure that all our employees who are affected by this make their applications in time. A commonly misheld belief from a lot of EU nationals I've spoken to is that if they've obtained permanent residency under EU law, then they do not need to do anything because they think, well, I've got permanent residency. You know, the clue's in the title, it's permanent. The fact is that that was under EU law. Now this is under UK law. They still need to make an application under the EU settlement scheme. And if they don't do it by the end of June, their status under EU law will lapse. Okay, so it's very important that they make this application by the end of June. Family members can join at a later date if they're not currently in the UK, as long as the relationship was in place before the end of December. What's making it difficult for employers is that you can't insist on seeing evidence that the individuals completed their settlement scheme application. And the reason for that is because the law doesn't oblige them to do it until the end of June. So the Home Office won't support you if there's no legislation or documentation to say you've got a right to ask for evidence of this application being complete. However, come the 1st of July, the law will change, and it will be an employer's responsibility to know their workers are all legal. So it's quite a difficult balancing act to deal with. And my advice really is to try and engage with and encourage your employees to get this done, provide them support, and it will give you an idea as to who's outstanding and who's not, without you actually insisting that they provide evidence. For a reminder for you all, these are the EU states that are all impacted. And of course, with this change in legislation and change of approach to these 27 nations, we have a change in the way we're looking at right to work checks. So a bit of a potted history here. From 2008, it's been an offence for an employer to employ somebody illegally. Pre-2008, it was mainly the individual that was committing the offence, but now the responsibility is on employers. The fine for getting it wrong could be £20,000 per employee, unless you have what they call the statutory excuse. And the way to achieve the statutory excuse is to conduct right to work checks. Excuse me. You must conduct the right to work checks in a very prescribed manner. You must see the person in front of you to know they're the rightful holder of the document. You must have the original document in your hand at the time you see the person to satisfy yourself that the document itself is genuine. So there's two checks you're doing. One, is it a genuine document? And two, is this person the rightful holder of this document? Once you're satisfied, you take a copy, you record the date, and that's your right to work check done. There are two types of employee. There's what they call List A and List B. List A employees are those without any kind of time limit or restriction on their stay in the UK. So that'll be your British national, somebody with indefinite leave to remain, and up until the end of last year, an EU national, because there was no restriction on them. List B is everybody else. So anybody on a visa with a time limit, so that could be somebody on a tier 2 visa, skilled worker, spousal visa, student, all these guys that have got a time limit on their stay. And these are List B. With List B employees, you need to check them every time their visa is due for renewal. So you need to have a system of tracking and monitoring and rechecking your List B population. And of course, your List B population is now going to become much bigger than it was before, because all those EU nationals will fall into the List B bucket. Okay, so there is that obligation. The difficulty presented is that obviously technology has moved on, and with the EU settlement scheme as a great example, status is now given electronically. There isn't a visa, there isn't a document. So if somebody is an EU national, they've obtained settled status or pre-settled status under the settlement scheme, they don't get a document. There's nothing they can show you as an employer. It is electronic. So what we have is an online right to work process, and this is something that will be in place for all individuals on visas from 2024, where we have an online system. So you can see on the left-hand side, there is a PDF letter to the individual confirming their status. And if they want to provide evidence to their employer, they need to go into the screen in the centre there, which is a portal, and they will put in their personal information, and they will generate what they call a share code. Okay, and that share code will be provided to the employer. The employer will get an email confirming that this individual is wanting to share their right to work status with them. The employer will go to their portal, and then they pop the number, and they will see something similar to this, which confirms the individual's right to work. Now, in this case, this would satisfy the statutory excuse. So all you'd need to do is to download this PDF and retain it on your records. Okay, so pretty straightforward, and it makes it much less onerous on the HR person, whoever's onboarding the individual, to be checking documents and satisfying themselves it's genuine and not being counterfeited or forged. So this does simplify things quite a bit. The other challenge employers have been having recently is obviously because of COVID. People haven't been in the office, so the Home Office have accommodated this by creating a slightly adjusted process for COVID compliant right to work checks. It only applies to those starting employment during COVID measures, so you can't say, oh, I didn't do it because it's COVID, and then they look and they see they started work in 2017. So it needs to be employment during the COVID period, and there must be a check completed later on after COVID. So I'll talk about that in just a moment. But with this adjusted process, the employer may accept an electronic copy of the document. Okay, so you don't need to see the original. Once you have that electronic copy, you then conduct a video call, satisfy yourself that the individual is the same person in the document you've got, and that would be your COVID compliant check. You'd need to mark that check quite specifically, as I've detailed here in this slide. It confirms the date of start, and that it was conducted in a certain way due to COVID. But once COVID measures have ended, you've then got 8 weeks to conduct a follow-up check. And that follow-up check must be fully compliant with the regular legislation. So you need to see the person in person with the original documents. Okay, so to wrap up, really these are the things we need to be thinking about. If you have a license already, let's start thinking about how many certificates of sponsorship will we need when it comes to renewal time, factoring in those EU nationals. We need to start thinking about the systems and processes. Are we capturing this data for EU workers? Have we adjusted how we look at them, which obviously feeds into recruiters and onboarding. Right to work policy is changing in July 2021. We probably want to get ahead of that, start thinking about ongoing right to work checks are going to require a bit more work with those individuals that are on pre-settled status. We've got those individuals that were on List A, who only required a one-time check when you first employed them, are now moving into List B because they're no longer free from restrictions. So that's our EU nationals. And we really do need to engage with the staff around making sure they get their settled status or pre-settled status done before the end of June. There is a massive risk to the business continuity if these people just leave it or don't really understand it. Equally, should they travel outside of the UK and then try and re-enter, if they haven't obtained this already, they're going to get challenged. The Home Office are going to say, well, how do I know you were living here before the end of 2020? How do I know you haven't just arrived from France and you've never been to the UK before? So there is, we need to think about the business impacts to not getting our hands around this. So that's our recommendations. We've got some time for questions. I've been rambling on for about 45 minutes. But if you've got any questions,
yes,
I think Sandra will.
Again, yes, you can. Perfect. Thanks so much for that, Darren. I think that was very informative, and there is so much information out there, but you've managed to convey it in a very succinct, straightforward way. So thank you. We've got one question by Andre and Jonathan. Is there an age limit or age factor in the skilled working visa application? For example, in New Zealand and Australia, age counts towards points. Is it the same in the UK?
None at all, no. It makes no difference. Obviously, you need to be at least a working age, but you don't get any points for it. There's no bonus points for being 35 as opposed to 65. It's exactly the same.
Thank you very much. And then a question from Andrew. Are there sponsor obligations if no person has been sponsored yet?
In order to obtain your license, you'll need to demonstrate you're able to meet your sponsor obligations. So even if so let's say today we've got no sponsored migrants, there's only 3 British nationals in the working for the business. We want to bring in somebody from Germany. You'd need to demonstrate that you've got the systems and processes in place that would enable you to meet your obligations as a sponsor. Once you have your license, there's a 4-year license, the Home Office commit to, they don't always do it, but they do commit to it, to visit you at least once during the lifetime of your license. Okay, so that could be a spot check. It could be completely, kind of unannounced, and they would come in and interrogate your systems and processes and files. They want to speak to everybody, see how it all works. So whilst you might say, one of the questions they ask is, if the person doesn't turn up for work, you need to be able to tell us within 10 working days. How does that work? And the answer might be, well, actually, it's in our employee handbook, where if somebody doesn't turn up for work, they need to tell their manager. Their manager and their management handbook is we make it clear that if one of their guys doesn't turn up for work, they need to let HR know within a day. Then HR know that they will need to tell the Home Office. So you could demonstrate that chain. Where it can sometimes fall down is because the Home Office will also interview the migrant, not just the people in the business, but they'll interview the migrants too, who work for the business. And if they say, well, what happens if you don't turn up for work one day? And the guy shrugged his shoulders and said, I don't know. Then you're going to be in all sorts of trouble, because it's all very well saying, we've got this fancy process, but if people don't know what their responsibilities are, then it won't satisfy them. So there's a very long answer to a very short question. The answer is yes, you need to be able to demonstrate you can do it, even if you haven't had to do it yet.
Brilliant. Thank you very much. And then could you very briefly explain the sole representative visa and if there's been any changes to that post-Brexit?
The sole representative visa is a bit of a dinosaur in the immigration landscape. It's pretty much remained unchanged for the last 20, 30 years. It is for an overseas company wishing to set up a representative office in the UK. They must send somebody who has the authority to act on behalf of the business, but it cannot be the business owner, okay? Because the point of the scheme is that you are establishing a branch. You're not moving the business. And so when you have a major shareholder wanting to come to the UK as a sole representative, the Home Office take exception to that. So they say, well, hang on a minute. If you're the controlling mind of the business and you're moving, then essentially the business is moving. And the sole rep is not for that. Okay. The sole rep is just to establish a branch. But there have been no major changes to it.
Okay. And would there be another option? The next question was, as a business owner, are you able to sponsor yourself?
That's a great question. And the surprising answer is yes. As long as you have the business established, you have an authorizer, so somebody already employed in the business in the UK who can deal with the certificate of sponsorship for you, yes, as a major shareholder, you can also hold a skilled worker visa. So you could essentially, I mean, the company can sponsor you, not sponsoring yourself, but essentially, yes, you kind of are because it's your business. But yeah, there's nothing to prevent a major shareholder now in the UK as a skilled worker holder.
Brilliant, thank you. And then one last question is, are you able to bring your family across if you get a skilled working visa?
100%. Married, unmarried, it's not a problem. Pretty straightforward. And also the trailing dependents are free from work restrictions. So in many ways, the dependents have got better visa status than the main applicant, because the main applicant is tied to the employer. It's one specific employer, and you're coming over to do a specific job. But your dependents can work without restriction. They can work for anybody. They could set up a business, work self-employed, study. So they have complete free reign, but they will only have as much time as the main applicant. So their status is completely linked to whatever the main applicant is given, but there are no work restrictions.
Okay, brilliant. Thank you. I think that's everybody's questions. I know a few people have asked for the register of sponsors. So Sandra has posted the link in the chat, but I'll post it again now for anybody that's missed it. And otherwise, thank you very much for joining us, and we will welcome your feedback, and you will get a follow-up email with a recording of the webinar, and you are welcome to follow up directly with any of us, and we are happy to offer a free, no obligation conversation to see if we are able to assist with your specific immigration query.
Great. Thanks, everyone.